Good morning, this is your Kelso Report for Tuesday, May 22nd, and I'm your host, Clark Kelso. Well, the Supreme Court has only about 5.5, 6 weeks left in their term, and their output now is going to start to climb as they close out the remaining opinions. We had 3 decisions yesterday from the Supreme Court dealing with Social Security benefits, court costs, and immigration. They granted cert in a standing case, and then on the Ninth Circuit we saw a case involving disabilities law, and in torts, California Court of Appeal, an interesting question about duty in the premises liability context. We begin with the Supreme Court, first dealing with Social Security benefits. According to the Social Security Administration, survivor's benefits to a person's biological children are available only if the children qualify for inheritance from the decedent under state intestacy law, or satisfy one of a few statutory alternatives to that requirement. Well, the children in Estrue versus Capado were conceived by in vitro fertilization 9 months after the father's death and were born another 9 months later. Under the applicable Florida law, posthumously conceived children do not qualify for inheritance through intestate succession. The children argued that the only requirement for qualification for benefits should be that they are the biological offspring. Although the statutory issue was not free from alternative interpretations, the Supreme Court unanimously concluded in Estrue versus Capado that the Social Security Administration's reading of the statute was better attuned to the statute's text and its design to benefit primarily those supported by the deceased wage earner in his or her lifetime. And I think equally important, that long-standing interpretation was entitled to Chevron deference, which is, I think, what accounts for a unanimous result in the case. Next, we have a decision involving immigration law. Chevron deference was also, I think, the overriding factor in this case. Holder versus Gutierrez. Excuse me. And it again probably accounts for a unanimous judgment. The issue in the case is a technical one, whether a child should have imputed to him or her the number of years a parent has resided in the United States as a lawful permanent resident. The background is that an immigration statute, Title 8, Section 1229B, authorizes the Attorney General to cancel the removal of an alien from the United States so long as the alien satisfies certain criteria. One of those criteria relates to the length of time an alien has lawfully resided in the United States, and another to the length of time he has held permanent resident status here. The Board of Immigration Appeals concluded that an alien living in this country as a child must meet those requirements on his own, without counting a parent's years of residence or immigration status. Excuse me. The Ninth Circuit had reversed, noting that the Immigration and Naturalization Service had a general policy prioritizing familial relations, and the board had in other contexts indicated a willingness to make imputations from a parent to a child. Citing Chevron deference as its primary justification, the Supreme Court unanimously held that the BIA's approach was based on a permissible construction of the statute, and therefore should be enforced by the courts. Next, the Supreme Court dealt with an interesting issue of court costs. The issue before the court in Taniguchi versus Can Pacific Saipan was whether compensation of interpreters, as a component of an award of court costs, includes the costs of translating documents, or whether it is limited to translation of live speech. Title 28 U.S.C. Section 1920 includes, quote, compensation of interpreters, close quote, among the costs that may be awarded to prevailing parties in federal court lawsuits. The Ninth Circuit held in this case that costs of interpreters included the cost of translating from Japanese to English certain documents that were used in preparing the defense. On a 6-3 vote, the Supreme Court reversed, focusing its attention on the ordinary meaning of interpreter as someone who translates orally from one language to another. While the word could possibly be stretched to include document translation, that was not its ordinary or plain meaning. The Supreme Court yesterday granted cert in Amnesty International versus Clapper, where the complaint alleged that new procedures adopted in Section 702 of the Foreign Intelligence Surveillance Act caused the plaintiffs, who were attorneys, journalists, and labor, legal, media, and human rights organizations, to fear that their communications would be monitored, and that forced them to undertake costly and burdensome measures to protect the confidentiality of international communications necessary to carrying out their jobs. Based on this allegation, the Second Circuit held that the plaintiffs had standing to challenge the constitutionality of Section 702, because standing may be based on a reasonable fear of future injury and costs incurred to avoid that injury. The Supreme Court has granted cert, apparently to take a look at the Second Circuit's standing analysis. Next, we turn to the Ninth Circuit Court of Appeals for a civil rights case involving disabilities law. In James versus City of Costa Mesa, we see the ongoing battle between California's medical marijuana initiative and contrary federal policy on marijuana use play out in the context of a suit brought under the Americans with Disabilities Act. Concerned about the possible shutdown of the collectives they rely on to obtain medical marijuana, the plaintiffs sought a preliminary injunction in federal court to restrain the defendant city from implementing the city ordinances that had the impact of shutting down certain marijuana collectives. The district court denied the request for a preliminary injunction because the ADA does not protect against discrimination on the basis of marijuana use. Even medical marijuana use, supervised by a doctor in accordance with state law, unless that use is authorized by federal law. The Ninth Circuit agreed over a partial dissent, holding that Congress has made clear that the ADA defines illegal drug use by reference to federal law, not state law, and that federal law does not authorize the plaintiff's medical marijuana use. The basic theme we've been seeing in all of these battles has been that the federal policy on marijuana ends up controlling. And now we have an interesting torts issue. The plaintiff in Campbell versus Ford Motor Company filed a premises liability action against the company, alleging she had been diagnosed with mesothelioma as a result of her exposure to asbestos from laundering her father's and brother's asbestos-covered clothing during the time they worked as independent contractors to install asbestos at a Ford plant in New Jersey. Applying California's leading duty case, Rowland versus Christian, the Second District held that the defendant did not owe a duty of care to someone who never visited the premises for injuries resulting from exposure to asbestos dust carried home from the workplace. As the court saw it, the issue was whether an employer has a duty to protect family members of employees from secondary exposure to asbestos used during the course of the employer's business. In holding that no such duty existed, the court was most concerned about the potentially broad scope of the possible plaintiffs who might be reached by finding such a duty, including anyone who might come into contact with the employee's clothes off the premises, such as fellow commuters or persons hired to do the employee's laundry. So the result is family members are outside the scope of duty that the employer owes with respect to creating a safe workplace. And that's it for today's Kelso Report. Have a great day in the law.